Good morning. This is a hearing now called to order. This is a hearing from the Committee on Public Safety to hear testimony on bill numbers 180741 and bill number 180978. I see the presence of a quorum. To my right is Councilwoman Blackwell and Councilman Green. To my left is Councilman Johnson, Councilwoman Parker, and Councilwoman Gim. I also see in the seat Councilman David O. Thank you for attending. Will the clerk please now read the title of the bills being considered today?
Bill number 180741, an ordinance amending section 10840 of the Philadelphia Code entitled Criminal and Defiant Trespassers to clarify and modify applicable definitions, penalties, and procedures, and to make certain technical changes, all under certain terms and conditions. And bill number 180978, an ordinance amending Title 10 of the Philadelphia Code entitled Regulation of Individual Conduct and Activity, Chapter 10800, Safety, by adding a new section 10841, fraudulent leasing of residential property, prohibiting conduct related to the fraudulent leasing of residential property, all under certain terms and conditions.
Thank you, Ms. Williams. I just want to say for the record that this council and councils before it have taken a hard look, a deeper dive into criminal codes that have the ability to impact people's lives for the good or for the better over the long term. As we make these adjustments, whether it's decriminalization of small amounts of marijuana to some of the nuisance codes that we deal with, and then to some more serious issues as it relates to property rights and people's ability to safely hold title. We've heard some of the horror stories about some of these issues, whether it's a young man who was selling a small amount of marijuana when he was a kid, wound up 30 years later not being able to work to his highest level of proficiency as a professional, or hearing about people who were in critical care units come out of that only to find out that someone had adversely possessed their home. So this body is constantly evaluating and reevaluating some of the codes that we have authority over. We recognize clearly that the federal government is the big level. The medium level is the Commonwealth of Pennsylvania, and we are but small fries, but we're going to make our mark known because we are the ones with boots on the ground who have to deal with the citizens that come to our office with these issues. So with that, Ms. Williams, wait a minute. Are there any others on the panel that would like to say a few words? Councilwoman.
Yes, thank you very much, Chairman Jones. First of all, I want to acknowledge and thank the work of my tremendous colleague, Councilwoman Cheryl Parker, for her leadership on this issue. This is an extremely complicated area of the law, and it really matters that we all work together to ensure that the law that we're putting forward takes into account the experiences and ensuring protections for all victims of this of serious issues that can happen unintended or intended. And Councilwoman Parker has done just a tremendous job leading us and helping us understand better all the nuances that happen within complicated areas, especially for some of our most vulnerable residents. I also really want to extend a note of gratitude to all the legal service organizations who are in the audience here. Thank you so much to our good friends at CLS, PELCOP, Senior Law Center, Turn, and others who've really been invested in making sure that the law represents a vast majority of citizens, many of whom can't afford to have lawyers, can't afford to understand all the nuances of law. Thank you so much for all the years of experience you've devoted to making sure that we get this right, that you work with us, hold us accountable, and look forward to this hearing.
Thank you, Councilwoman. Are there any others to Councilman O? Chair recognizes
Thank you very much,
Councilman O.
Chairman. My first question to everyone is, how did this hearing end up before this committee? What I mean is, the issue was raised originally April 25th, 2017. It was introduced as a bill. It was introduced as a resolution. My bill, actually, to deal with criminal and defiant trespassers was assigned to this committee. Councilman Taubenberger's resolution to have a hearing on the totality of these circumstances was assigned to Alan Dom's committee, the Housing Committee. Council President came to me and said, in order to consolidate this for efficiency and effectiveness, I'd like to move your bill from the Public Safety Committee to the Housing Committee. And Councilman Taubenberger asked that I do the same, and I agreed because we should have it under one committee. Since that date, we have had numerous hearings in front of the Housing Committee. We've had numerous meetings, including the Police Department, the District Attorney's Office, the City Solicitor's Office, Community Legal Services, tenants' rights groups, and other organizations. My bill was defeated by a vote of 4-1. And then we had continuing conversations under that committee, under the leadership of the chairman, Alan Dom. A new bill was introduced on this very same topic by Councilman Al Taubenberger, assigned to the Housing Committee. And then I introduced the bill that was assigned once again to the Housing Committee. And so all negotiations, conversations, discussions have been held before the Housing Committee. And until Thursday, I did not know, Councilman Heenan did not know, Councilman Dom did not know that this committee would be holding this hearing, and therefore we're unprepared. What I will say is that in the short time I've been here, I have read Mr. Gould's testimony. I think it is consistent. He has said the same thing all along. He has not changed any of his points about people who may be harmed prior to my bill and after my bill. This is not a complicated topic whatsoever. There are homeowners in Philadelphia who come home to find criminals in their home. I don't mean strangers who were mistaken, broken into their home, keys taken, property sold, and the efforts of the champions of these criminal and defiant trespassers has been to make the homeowners unable to get in front of a judge faster. The bill that you're trying to amend simply allows the person who is the homeowner, who has the evidence, to contact the police, and the police used to not get the information, and if the police don't make an arrest, under the directive, they can have a detective look at it. If the detective chooses not to make an arrest, they have a procedure whereby they can get in front of a judge. All the questions that Mr. Gould identifies, are you a victim, were you scammed, all that, do you have a legal right to be there, has to be determined by a court of law, by a judge, not by a police officer. Therefore, no police officer is removing anybody under the bill. But under the ordinance, but under this bill that is proposed, those rights and those protections for homeowners are being stripped away. Let me give you some examples. There are exemptions now for homeowners who want to use the ordinance. A person in their home simply has to say, I'm a victim of domestic violence, sexual harassment, or stalking, not necessarily by the homeowner, but by someone who might be a criminal and defiant trespasser as well. And now, instead of getting into court within 30 days, as we try under our ordinance, you'll have to go through the same process of ejectment, which typically takes 6 months, and in many cases, based on our testimony, 12 to 14 months. What is the problem with getting in front of a judge to have a judge make the determination faster? In addition, if the criminal and defiant trespassers claim to have fallen for a scam, then the amendments say that the homeowner, that the criminal and defiant trespasser, even if they make a claim that they were a victim, they have to have the trespasser in their home for up to 15 days. Where will the homeowner go? Most of the folks that we have heard from are senior citizens. They are poor. They don't have another house to go to. It also allows for a vague standard that before the homeowner uses or contacts the police or uses the ordinance, they have to conduct a reasonable investigation. The homeowner calls the police. The police do the investigation. Under this amendment, the homeowner now has to conduct a reasonable investigation, and it creates a private right of action against them. It exempts individuals who unknowingly engage in criminal and defiant trespass. I'm not sure what that is, but it's an easy claim to make. I thought I was supposed to be in here, so I kicked in the door, I changed the locks, but I did it unknowingly. All of this is really to make it more difficult for the homeowner who's already challenged in Philadelphia. And then finally, we created a deterrent because of the criminal and defiant trespassers who we have found to purposely break into people's home with the idea of getting $3,000 cash for keys, except they're not leaving. They're staying there a long time. And so we have in our ordinance $300 fine per day up to the judge and up to 90 days in jail. This amendment gets rid of that and creates a maximum fine of $1,000. Listen, you can't even get these people out of your house for $2,000 or $3,000. What I would say is this: we have spent numerous hours meeting with the same people sitting there, talking with them time and again, getting their letters, having conversations, trying to reach compromise with them, but they're never satisfied with the compromise. We have finally passed an ordinance. The ordinance has passed. Now we're going to hear this testimony in front of a new committee because the chairman of the committee was trying to get a level of conversation between CLS, tenants' rights folks, Senior Law Project, the homeowners, HAPCO, and the victims. So with that, I would urge you to send this back to the committee that has heard all of this testimony, dealt with all of this, and otherwise to do your best. Thank you.
Thank you, Councilman. And all of that was recorded on the record, and some of your concerns, questions, and objectives. I'm only going to respond to one of them, which was the very first one: how did it get to my committee? As you articulated, there is a lot of criminal and possible legal action that might be in the criminal area. So in my opinion, as Chair of Public Safety, this is truly an appropriate place to have those aspects aired. I also note that the Chair of Housing is also on this committee, which adds to the level of discussion because of her expertise in the area. Thirdly, you only have to look at the news from a 24-hour news cycle in Southwest Philadelphia. There were 4 people found dead, shot to death in a dwelling, and it may have been a result of criminal trespassing. So all of these things are reasons why it, in my opinion, it is appropriate to be here. Some of the backroom discussions I wasn't privy to. I was at the same meeting you were at the caucus when it came up. And so maybe, and I can't speak for others, that some of the amendments, some of the concerns are more from a different lens of public safety. And if that is the case, then it is truly appropriate that it is here. With that, I'm going to recognize Councilwoman Parker.
Thank you, Mr. Chairman and members of the committee. Before I start with my comments, I just want to note for the record, one only needs to look at the state of our great nation, to value the importance of fact versus fiction. Fact versus fiction. And the absolute truth. And the great thing about facts and not an interpretation that is subjective are that facts don't change. And so it's with that in mind that I want to state the obvious. And Mr. Chairman, I want you to thank you in advance for the leeway, because based on the opening remarks that we just heard from one of our colleagues, it is very important that for the record, I get the information that I am about to state on the record, because it will address much of what I consider to be misinformation that was just communicated. With that being said, I want to state the obvious. It has been, currently is, and will remain illegal to trespass or break into someone's home and take up residence. There are no squatters' rights, for the record. Squatters' rights have not and do not exist. It is illegal to squat. First, squatting is illegal under state law, and if arrested and prosecuted, you will face penalties such as fines and/or jail time. Second, under my bill, number 180741, the bill that's being heard here today, squatting is deemed a prohibited conduct and can lead to both arrest and municipal civil fines. Unfortunately, significant misinformation about bill number 180741 has been distributed via social media through various communication outlets, and the misinformation has encouraged some to come here today to testify against bill number 180741. And if you are here to testify against it, I hope you will listen carefully to what I'm about to say and then ask yourself whether or not you're still opposed. If you retain nothing else, please listen to this sentence. Bill number 180741 protects rightful home dwellers and victims of fraud. And while ensuring that those who trespass or break into someone's home will face arrests and fines under the city code and criminal penalties under existing state law. There are three main differences between my bill and the current law on the books regarding criminal and defiant trespassers. Now, some people may want to, and I'm not sure if you'll be able to read it, but we have actual copies of this for anyone who is in the chambers, anyone who is at home watching. You can request a copy electronically, and this information has been distributed well in advance to all members of this committee. The first difference. The bill on the books currently states the following types of individuals cannot be deemed criminal and defiant trespassers: an individual with title to the property, an individual with permission of the owner or authorized agent, an individual who has any sort of interaction with the owner that would indicate a landlord-tenant relationship under state law. The difference, my bill states that the following types of individuals cannot be deemed criminal and defiant trespassers: an individual with a title to a property, an individual with permission of an owner, and not just the owner. Because if you live in some of our neighborhoods and mom dies and the home is being left to family members, sometimes there are three owners instead of one. That is, not something that we've just created. There are multiple instances, particularly in communities, where someone passes away and doesn't have a will, specifically identifying who the owner is. A prior owner who had legal authority to grant such permission at the time, a prior tenant who had the legal authority to grant such permission at the time, and/or an authorized agent of any of these. An individual who has any sort of interaction with an owner that would indicate a landlord or tenant relationship under state law. You heard it mentioned earlier. A victim of domestic violence, sexual harassment, or stalking that has been perpetrated by an owner or by another person who is currently or has recently lived with the victim. Now, please note, this language is specifically to protect victims living in the same household as their abusers who may have the deed in just their name. This is to prevent abusers from turning around and threatening their victims. Get out of the house now, or else I'll call the police and I'll say you're a squatter so that they can come and arrest you. Until you've walked a mile in someone else's shoes, don't claim what you know can and cannot happen. A victim of residential lease fraud, or someone else with a legal claim to reside in the property, including but not limited to someone with the right to redeem their property after sheriff's sale, someone who is buying the property in an installment sales contract, also known as rent to own. For those of us who represent districts with a high rate of home ownership, where people are constantly getting this, we'll buy your house for cash, letters in the mail, or we have a rent to own program, and you should come and buy from us. These kind of scams run rampant. And or someone with a right to reside in their property under the Federal Protecting Tenants and Foreclosure Act. Second main difference. My legislation provides protections for those who have been falsely accused of being a criminal and defiant trespasser, as well as protections for victims of residential lease fraud. For individuals who have been falsely accused of being a criminal and defiant trespasser, Bill number 180741 puts in a fine of $1,000 if someone knowingly files a false affidavit with the police or fails to correct a material statement that they subsequently learn to be false. Bill number 180741 also includes language that makes it easier for those who have been falsely accused to seek restitution in court. For victims of residential lease fraud, I want you to just bear with me. Imagine that your mother has recently become a widow. She decides that she can no longer maintain the house she was in, and she wants to rent a smaller house, and she wants to be closer to you. She finds a listing. She puts down her first month and her last month's rent and her security deposit, and she moves in. A few months later, someone shows up at her door and they tell her, you have to get out immediately because you are a squatter. Now, under the law, as it is currently on the books, your mother will have not only just lost a significant amount of money to a scammer, but she would also be subject to a $300 compounding daily fine for every day that she remains in the property, as well as potential jail time. Now, do you really think it's fair to further penalize someone who has just been defrauded, particularly with jail time, particularly with all of you MacArthur grant supporters who are in the audience who said Philadelphia was on the right path? Now, I realize that when someone is a victim of residential lease fraud, what happened to them is not fair, but they still have to vacate the property. So I don't want anyone to think that we are softening what is considered to be a crime. We are saying if you've been a victim, unfortunate, sad, but you still have to leave. And that's why we have language included in this bill that is not in the current law that I should mention, that states that the police must notify the victim in writing that such victim cannot legally remain in a residence and must make arrangements to move out within 15 days. My office has developed this 15-day language after a conversation with various departments of the administration, including police, law, the Office of Supportive Housing, as well as the District Attorney's Office. Finally, it is specifically because I have seen an uptick in residential lease fraud recently that I introduced Bill number 180978 as a companion bill to 180741, because while it is obviously already illegal at the state level to create a fraudulent lease, my bill imposes a civil penalty of $1,000 for each violation. Additionally, Bill number 180978 also makes it easier for both the actual owner of the property and the victim of lease fraud to seek restitution in court. The third main difference: my legislation changes the civil penalties for criminal and defiant trespassing. The way the law is currently written, the penalties for criminal and defiant trespassing compound daily. What does that mean? On day 1, $300 or a 90-day jail stay. Day 2, $600, 180-day jail stay. You get it. This means that for every 4 days a squatter is in a house, that's almost a year in jail. 1 month is 7.5 years in jail. And as you know, many of these squatting cases have taken 6 months or more to resolve. So 6 months, that would be a total of 45 years in jail, MacArthur supporters. I think we all agree that these squatters need to face consequences for their actions, but 45 years in jail is, quite frankly, quite laughable. Especially when you're not the taxpayer who has to foot this bill. Especially in this area when we're talking about bipartisan criminal justice reform. 180741 removes the daily compounding 90-day jail stay because those criminally prosecuted under state law for trespassing, they already face a potential jail sentence. Additionally, the way the law is currently written, I want you to think about this, and I want you to think about our police districts. It requires the police to physically go out to the property each day to issue the $300 fine. So that means every day the police will have to go out to a particular property and issue this fine. This not only creates implementation challenges, but quite frankly, our police force, 4 people in the basement in a house found murdered. I want them investigating at that house and not telling me that they have to take someone off of that assignment to go on a daily visit to another property. I'd rather them be spending their time stopping violent crimes than going back to the same house each day to try to issue a fine. Instead, this bill has a $1,000 fine for first-time squatters and a $2,000 fine for repeat offenders, meaning they go back to the same house after arrest or they go to a different house. This fine will still serve as a deterrent while also making it much easier for the police to implement. Finally, now that you've heard me explain the bills, I hope it is clear to everyone that it aims to protect rightful home dwellers and victims of fraud, while ensuring that those who trespass or break into someone's home will still face arrest, fines under the city code, and criminal penalties under state law. I too want to join my council colleague, Councilwoman Gim, in saying a special thank you to our legal aid organization, CLS, Senior Law, Public Interest, and the Tenant Union Representative Network. They are the organizations who are on the front lines every day, protecting our city's most vulnerable and elderly. They are the ones who have been consistently sounding the alarm that the law on the books could further threaten our most vulnerable constituency. Next, I want to say a special thank you to our law enforcement agencies, particularly the police and our district attorney's office. I was incredibly grateful that when the police department released their new directive regarding squatters on September the 28th of this year, they showed that they got it. And what I mean is that they understand that not everything is black and white, that there are numerous circumstances where someone may have a legal right to reside in a property, but for one reason or another, they don't have a deed in their name. We didn't make that up. These are cases that are quite common in many of our neighborhoods. With that being said, a police procedure is just a procedure. It's not a law. And it can change under new leadership, which is why I want to codify protections for the most vulnerable, while also still ensuring that squatters will face arrest, fines under the city code, and criminal penalties under existing state law. As for the DA's office, they have been a tireless partner in working to enhance protections for the elderly, the poor, victims of domestic violence, and the vulnerable, while still making sure that they work to stop fraud and corruption. In closing, I want to leave you with one more thing. I just mentioned that while the new police procedure shows that they get it, just imagine if they got it wrong. Their procedure shows that they understand the very intricate nuances. But just imagine if something happened and we got it wrong. Meaning, just imagine if someone who had a legal right to reside in their property was arrested and they were put in jail. Can you imagine the lawsuit and the multi-million-dollar payout that the city would have to make? My bill number 180741 will protect the city against such lawsuits. And finally, for the record, and I've got to state this because this is on my spirit, it is a joke for anyone to contend that all of the stakeholders who have a nickel and a quarter of putting together this legislation, that from the very beginning they were at the table. I would dare say you that it was not until we passed a resolution in this council calling for the creation of a task force, and we held our meeting right across this hall in our council chambers with law enforcement along with our legal aid organizations and anyone who would have a role in this process. That was the first time they were all brought to the table. So I don't know about any individual meetings that occurred in silos or using a secret way to communicate, but I would dare say to you that every organization who is coming to testify here today will tell you that they never got together as a whole the way that they should have in order to develop this legislation, to hash out details, responsibilities in a very real way. I know it's the much more difficult way. It takes a longer time to do it that way, but fortunately for me, it is the only way that I know how to get things done, and that is bringing everyone to the table at the same time, no whispering campaigns, but whether they agree or disagree, to make sure everyone's perspective is heard. And for those who are watching at home who are saying, Councilwoman Parker, you know, we feel that you're a tad bit passionate and overly spirited right now. If you knew the hell I went through and the very diplomatic silence that I've had to demonstrate while watching the information be shot to reporters, to be sent on social media, almost used as a way to bully some of my colleagues who know that this is a highly public and charged and emotional issue. And they've taken this information to really powerful community organizations as a way to say, you know, we deal with this issue of squatting and tough law and order that doesn't make a damn bit of sense. We want that to stand. Well, I'm not going to let anybody bully me. The facts matter. They could be in Washington or in Harrisburg or in Philadelphia, but I don't care who you are. You won't bully me. You don't scare me. And I'm going to speak my truth no matter how difficult it may be for you to swallow. To my colleagues, I thank you so very much. And Mr. Chairman, the leeway that you just granted me, I am very grateful and appreciative of it, but I've gone through hell in just trying to do this right. Thank you.
Thank you, Councilwoman. You sure you don't want to tell us how you really feel? You did, and I appreciate it. I appreciate my colleague. Let me just say this. We are not a monolithic body. We come from different points of view, looking at the same subject. We can see things very differently. But what I will say is that all of us, I can safely say without fear of contradiction, passionately represent our constituents' voices. I want to say that I've always enjoyed the back and forth between different groups as well. If you're talking about the tenants union or Phil Lord and his decades worth of advocacy, or the HAPCO folk and apartment, I've had them in my office on other issues, and we've agreed on a great many things, agreed to disagree on many things, but I think at the end of the day, at the end of this process, you'll have a better, well thought out public policy issue. And that's why we are here, to have hearings like this, not to always go along to get along, agree, but to have it on the record in public discourse and come up with a solution. Because an inaction is an action. If we do nothing, we've done something. and we've done something to somebody. So with that, I see your counterpoint, but what I'm going to do is allow the clerk to bring up the first group to testify, and then you'll be recognized.
Inspector Francis Healy, Mike Lee, and Kimberly Essek.
Thank you all for your patience. Please approach the witness table. Have a seat. Pull the mics close to you. State your name and title for the record, and please begin your testimony.
Would you like to go first? No, ladies first.
Good morning. Kimberly Essek, Assistant District Attorney. Assistant District Attorney, Economic and Cyber Crimes Unit, District Attorney's Office, Philadelphia.
Good morning. Mike Lee, Director of Government Affairs, District Attorney's Office of Philadelphia. And I will be reading some prepared testimony, and then collectively we are available to answer any questions this committee may have. Good morning, and thank you, Councilman Jones, as Chairman of the Public Safety Committee, and other members of the Public Safety Committee and council members and public in attendance. My name is Mike Lee, and joining me today is Kimberly Essek, Assistant District Attorney for the Economic Crimes Unit from the District Attorney's Office. Home ownership is one of the greatest privileges of our society, and it comes with some of the most responsibilities. Determining the legal, equitable, and title ownership of residential properties requires detailed case-by-case investigation because of the complex interrelationship of property rights. This is why property rights are often referred to as, quote, a bundle of rights. The District Attorney's Office supports the intention of Bills 180741 and 180978 because these bills add clarity to the bundles of rights surrounding residential property ownership and the issues that arise from there. The District Attorney's Office will continue to support legislation that strengthens the protection of property owners and victims of criminal trespass while balancing the interests of tenants, victims of fraudulent leases, domestic abuse, and other vulnerable populations. While the District Attorney's Office will continue to rely upon and enforce Section 3503 of the Pennsylvania Crimes Code, criminal trespass, these bills will improve the District Attorney's Office response and consistency for residential property controversies. During the fiscal year 2019 budget hearing testimony, District Attorney Krasner committed to addressing economic crimes involving residential properties. Subsequently, the District Attorney has dedicated resources to expanding the Economic and Cybercrime Unit and improving practices surrounding the unique challenges of economic and cybercrime investigations. The District Attorney's Office understands that making the distinction between civil and criminal activities surrounding residential properties can be arduous, and we are working with law enforcement and community partners to improve procedures to secure sufficient evidence to determine if and when an arrest can be made. The Economics Crime Unit has collaborated with and trained other criminal justice stakeholders to improve investigations, their techniques, and their outcomes. This unit, Economic Crimes, will continue to work closely with all stakeholders to help stabilize the housing market and increase public safety by prosecuting people who take advantage of the elderly, the poor, and current gaps in our legal system. Thank you.
So hold that thought. I have business to attend to in my district, but before I leave, I would like to record my vote, and therefore would like to recess the public hearing and go into a public meeting.
Second.
Well, I didn't call for that. But I appreciate your enthusiasm. I would now like to be recorded as voting aye on any motions and approve any amendments to these bills, and I would also like to be recorded as voting aye on any motions to report these bills with a favorable recommendation and any recommendation that the rules be suspended to permit first reading at our next session of council. We will now go back into our public meeting, and I will relinquish the chair to Councilman Johnson.
Any questions from members of the panel? Let me reset. Did everybody get a chance to?
Would you like me to read the
Yes, sir.
Sorry. Good morning, Councilman Jones and other members of the Committee on Public Safety. My name is Francis Healy, and I'm Special Advisor to Commissioner Ross. First, on behalf of the Commissioner, I'd like to thank you for giving the Philadelphia Police Department the opportunity to voice its opinion regarding Bill number 180741 regarding criminal and defiant trespassers and Bill number 180978 regarding fraudulent leases. As you know, the Philadelphia Police Department supported the passage of Bill 180430, which amended Title 10 of the City Code by adding a new section entitled Criminal and Defiant Trespassers. Due to a relatively new and emerging crime whereby offenders illegally occupy or fraudulently lease residential properties to unsuspecting renters, Commissioner Ross directed that a policy be developed and implemented to address the criminal activity, but also to better serve the victims of these crimes. The policy, which is known now as Directive 5.31, provides clear instructions for responding officers and the assigned detectives when dealing with this complicated financial crime. To be very clear, these criminals are not homeless individuals squatting on vacant property to get out of the elements. They are individuals whose expressed intent is to deprive the owner of his or her property and to use this property to intentionally defraud unsuspecting victims. Accordingly, the Police Department supports Bill number 180741 as is proposed to be amended, and for this reason, the Police Department also supports Bill number 180978 relating to fraudulent leases. The Department views Bill number 180978, fraudulent leases, as a companion bill to the existing City Code, Section 10840, and the proposed amendments in the bills discussed today. As mentioned, the Department has implemented and developed a comprehensive policy on how to deal with both the criminals and defiant trespassers, as well as the innocent victims that occur from fraudulent leases. This policy is consistent with the City Code Section 1040 and the amendments being made here today under both bills. As such, the Department fully supports both. At this time, I'd be happy to answer any questions.
Any questions from members of the panel?
Yes.
Councilwoman Sherelle Parker.
Thank you, Mr. Chairman, and thank you all so very much for your testimony. Relative to the police department, can you provide us with just a general overview of the new police procedure, Directive 5.31, which went into effect on the 28th, just almost like a checklist for the benefit of those watching?
Just so as you know, as a background, what we did not have in place prior to this, prior to this directive, was specific instructions for responding officers, and then the follow-up by detectives on how to deal with this financial crime. It's a relatively new crime. I say relatively new, but the Philadelphia police officers that respond were ill-equipped to deal with those type of complicated issues. Much like we would handle any other serious crime, an aggravated assault, something along those lines, the victims need to have service. So we made sure that what we put in place was step-by-step instructions for the responding officers, basically to make sure that the victims of these are either transported to the detective divisions to make sure that that they get service first and foremost. And the next thing is instructions for the detectives on how to investigate these things in collaboration with the District Attorney's Office. The District Attorney's Office is obviously the expert in weeding out a lot of these issues, but they're working hand in hand together now that they did not do before. So right. I think they're in a right path in the right direction.
Right, so I just want to be clear. The new police procedure is mostly focused on enforcement of already existing state law. And like, for example, it's already illegal to trespass and break into someone's home and take up residence. Am I accurate? Is that an accurate statement?
Our directive is not impacted by the city code ordinance.
Great, okay, that was the next question. Tell me, how has the rollout gone so far? Like now, at least we have a point of entry. We have a place to tell everyone, no matter what section of the city that you are in, that this is what you should do to get started with this process. So how has it been working?
It's slow and steady. As with any new policy or new change, it changes the culture. It's a cultural change. So it's a step-by-step process, but to ensure that this process gets hammered home to the detectives as well as the officers, and as well as the detective unit supervisors, we regularly put out a teletype training announcement to be read to the officers and detectives on a 3-day period. We'll do that at least for the next 3 months, 1 day a month, to make sure that this message is constantly revisited, and that way like I said, it's a change in culture. We want to make sure everybody gets aboard on it. The officers responding on the street really are the key to this. As long as they get out there and they understand this is something beyond me, now they know what to do. They just don't have to stand there and say, well, I'm sorry, I can't help you.
Right.
And that's the biggest thing. That was really the biggest concern to Commissioner Ross, that when we were out there, when we had a legitimate victim, that we just don't stand there and say, well, I don't know what to do to help you. Now the officers have clear instructions.
And just for the benefit of those who are in the chambers and those who are watching, I want you to confirm for me whether or not I would be accurate in noting that this police procedure that you all have established, this directive in the police department, did you need legislation to create it?
No,
The directive?
we implemented it, or we had it drafted prior to the implementation, yes. We did not need legislation.
So no legislation was needed for this directive that was developed by the police department and is now a formal process, standard operating procedure, did not need legislation to be created. Is that accurate?
That's correct.
And just for the record, will this police department's directive, will it be changed by Bill number 180741 that's before us today?
One minor tweak.
And one minor tweak.
The issue is we have a provision in our policy when we have an innocent victim renter. The issue is that you mentioned correctly, they have to leave. We put in my policy as soon as possible. What I do is I have the victim assistance officer, it's their responsibility to interject themselves into these incidents to try to transition the defrauded victim out of the house as soon as possible. You put a 15-day window on it. So I'll have to just tweak that and say as soon as possible, it'll be within 15 days.
Thank you. Overall, I want to ask the DA's office, when you came to our meeting, the first task force meeting that was held across the hall in City Hall, and I'll also ask the police department to respond to this, was that the first time that both the district attorney's office along with the police department had ever come together with law, with all of our community legal services, with the sheriff's office, with the courts? Was that the first time that all of those entities who have a role, some way, shape, or form in this process, was that the first time you were all at the table together meeting about this issue?
To the best of our knowledge, yes.
To the best of my knowledge, that was the largest, most comprehensive meeting, yes. I can't say for sure that the matter hadn't been discussed prior, but in a much smaller setting. I can say that.
Thank you very much, Mr. Chairman.
Thank you, Councilwoman. Any other questions from members of the panel? Thank you very much for your testimony. Would the clerk please call the next panel?
George Gold, Kateria McCabe, and George Donnelly.
Chairman, before that, may I respond to the statements made earlier?
Sure, Councilman David O.
Thank you very much. There is misinformation. Unfortunately, I believe the misinformation is from the lawyers at CLS to members of this body. That's the first thing. Those same statements had been made previously and had been fully discussed. First of all, the misinformation centers around the fact that the ordinance that is now in place needs to be amended. And the police and district attorney's office also testified in support of the bill, which is now an ordinance. The only thing that the ordinance does is it allows a homeowner, after they have called the police because of a criminal violation where the police do not make an arrest. And unfortunately, in this city, there have been many times where people have reported doors kicked in, windows broken into, numerous people, 5, 6, 7 people in their homes. They came here and testified, and the police did not arrest them, did not take action. In fact, the police and the district attorney's office told them to file in landlord-tenant court, which is the wrong court. When a homeowner comes across a criminal violation of their home, and the police do not make an arrest. That is the only reason why we created this ordinance. It is limited to those fact circumstances. And so, when the homeowner cannot get the police to do their job, or when the fact scenario is complicated and the police are not sure what they should do, the problem has been it has taken 6 to 14 months and sometimes longer to get in front of a judge. The only thing the ordinance does is it accelerates the time so a homeowner and the person who is in the home, if they are a criminal trespasser or if they are the legitimate victim of a scam, or if they have some claims to be in the home, can get in front of a judge, because a judge will have to make that determination. That is why the first factual statement or concern about who is not listed in the ordinance is not accurate. Anyone who has a claim can bring it when they get in front of a judge. Let's say it's 30 days and say, Judge, I'm an heir, or any of those type of things. However, you cannot even use this ordinance without first contacting the police and describing and articulating and recording a criminal violation. The next thing is that for persons who abuse the ordinance, they too are subject to a $300 per day fine, which does accumulate, and up to 90 days in jail, which does accumulate, but all civil ordinances are limited. You cannot have more than a certain fine. You cannot have more than a certain number of days in jail. So they do not go on forever. We are not allowed to do that in the city of Philadelphia. Civil fines are limited. Civil jail time is limited. They don't go on forever. But both the criminal trespasser, defiant trespasser, and anyone who intentionally abuses this law are subject to the same penalties of $300 per day and up to 90 days in jail. It is up to the homeowner. If the homeowner needs a home, then as the captain said, the person, whoever they are, should leave the home as soon as possible. When the government says you have up to 15 days to remain in somebody's home, in many cases with their food, their furniture, their clothing, their jewelry, that is not for the government to say. If the government would like to provide shelter, money, help, but that should not be put on the homeowner who may not be able to find another home or place to live. Leave that up to the homeowner, and the government can certainly help people who need help. And then finally, the civil penalties and all other things are determined by a judge. We trust the judges who hear these cases. The only thing our ordinance does, which we passed 11-6, is to allow someone to get in front of a judge that has the authority to make these determinations. In part, the amendments that have been forwarded by CLS and the tenants' right folks simply create less opportunities for homeowners to get into a court. That's all. Thank you.
Thank you. Can members of the panel please state your name for the record and begin your testimony?
My name is George Gould. Good morning. I am a senior attorney at Community Legal Services, where I have worked in the area of housing for almost 50 years. I thank the committee for giving me the opportunity to testify today on this important issue. I have also been actively involved in housing legislation at the local, state, and national level. I am very grateful to have worked with City Council for decades to protect the rights of tenants and to promote decent, safe, and affordable housing. First, I would like to discuss Bill 180741 and its proposed amendments, which would make important changes to the criminal trespass ordinance, which was passed by City Council and became law in September 2018. We recognize that Philadelphia is facing a problem of criminal trespass by those who have no legal right to occupy a property. However, we submit, with all due respect to Councilman O, that the current criminal trespass ordinances has serious problems, and that ordinance does a lot more than simply create an expedited hearing. It defines who are criminal trespassers. The definition of criminal and defiant trespasser in the ordinance is so broad that it includes many people with legitimate ownership or occupancy rights to a property. Among them are property owners who retain the right to possession after tax sales during the statutory redemption period. A tenant who has the right to reside in the property after the owner has lost it under federal law. Heirs to properties, victims of domestic abuse, sexual abuse, and stalking, and persons who obtain title under the Pennsylvania Adverse Possession Law. The ordinance oversimplifies who is or is not a lawful occupant and does not adequately protect legal and equitable owners. There are more than 14,000 properties in Philadelphia titled in the name of people who are deceased. Their heirs have rights to the property. They may just lack paperwork or are stymied by the Philadelphia's tangled title epidemic. There are also many situations, such as installment sales agreements, where an agreement signed by a previous owner remains valid even once that property is transferred. The limited carve-out in the ordinance for occupants with a landlord-tenant relationship with an owner or prior owner do not adequately protect occupants who have ownership interest. Moreover, the ordinance does nothing to protect tenants who have been scammed by fraudsters that rent out properties which they do not own. Every lawyer serving tenants in the city has come across cases like these, where a person will say he or she owns an empty property, rent the property to an unsuspecting tenant who thinks the rental is legitimate, and then disappear after receiving a deposit and several months of rent. The ordinance criminalizes people who have been victims of this sort of fraud by placing them squarely within the category of criminal and defiant trespassers. We strongly support Bill 180741 and the opposed amendments to it. They would resolve many of the problems with the current ordinance. At the June 4th hearing, you heard from several CLS clients, including Morris Simpkins. Mr. Simpkins lived in his family home for more than 60 years. After the house was sold to Sheriffdale for property taxes, the purchaser repeatedly called the police and reported Mr. Simpkins as a squatter. Under the city law as it currently exists, Mr. Simpkins would be facing potential fines or jail time simply for living in a house he had a right to live in. You also heard from Margaret Green, who signed a lease and paid rent for many months after the landlord disappeared. After 3 years, a new person came knocking on the door, demanding interest to the property and claiming to be the owner. But his ownership was a deed purportedly signed by two women who had been dead for over a decade. The current bill and the proposed amendments to it make it clear there are other legitimate residents residing in the property beside, quote, the tenant. The bill and the amendment specifies that a criminal and defiant trespasser is not, and I use the word is not, a person who, quote, has a claim to legal or equitable title of such residential property. A victim of domestic violence, sexual harassment, or stalking under Section 932018 of the Code, and this is important, that has been perpetrated by an owner of such property or by another person who recently lived with the victim in such rental property, end of quote. A person, quote, who paid rent to an individual whom such person believes in reasonable good faith is either the owner of the residential property or has authority to rent such property, end of quote. This provision would protect innocent victims like Margaret Green. The proposed amended bill provides the victim has 15 days to move out or such time as provided in police directives. Quote, the former owner of a residential property sold at a tax sale claiming a right to redeem before the end of the redemption period of Pennsylvania law, such as Mr. Simpkins, who was ultimately able to save his longtime family home. Quote, an individual who is a buyer of a residential property under an installment sales contract. Quote, an individual whom the property is conveyed pursuant to an unrecorded deed. Quote, an individual with a right to reside in the residential property of the Federal Protection Tenants at Foreclosure Act. Quote, a person who has obtained title by adverse possession under Pennsylvania law. It's interesting to note that I read the testimony of the 3 landlord association realtor groups, and they claim these are all loopholes. These aren't loopholes. These are rights that people have to live in a property, and it's very important they be spelled out. The bill and amendments also provide that the affidavit signed by the owner, to the best of the affiant's knowledge, information, and belief, after such affiant's investigation, does not have a claim to reside in the property, as set forth above. We think this is very important. Councilman O, I think, has some issue. Why require the person to do a reasonable investigation? I think it's critically important that if someone is accusing and going to the police that they are a squatter, that they know what the law is and what the exceptions are. In addition, the bill addresses the issue of victims of fraudulent leases and creates a private right of action for persons wrongfully accused of criminal trespass. We also support Bill 180978, which addresses the serious problem of scammers fraudulently leasing a property they do not own. The bill would create a fine up to $1,000 and a private right of action for the victims against the scammers. We suggest that the proposed fine be increased up to $2,000 and the damages be for each day the violations exist. I thank you very much for giving me the opportunity to testify on these important issues. I would also like to thank Councilwoman Parker and her staff, and in particular Rachel Meadows, for all their great work on that. They have persevered for many, many months, and we really, really appreciate it. And I also wanted to thank Frank Healy of the City Police Department, the City District Attorney's Office, and the City Law Department for all the work they have done on this important issue. Thank you.
Can the next panelist please, hey, Katia McCabe, how you doing? Can you please state your name for the record?
I am Kateria McCabe, Director of Veterans, Kinship Care, and Tenant Rights at Senior Law Center. Thank you, Acting Council Chair Johnson, and members of the Committee on Public Safety for the opportunity to provide Senior Law Center's response to the 2 proposed bills that will increase protections for Philadelphians at risk of displacement from their homes and will provide a remedy for residents who are victims of fraudulent leases. At Senior Law Center, we protect the rights of older Pennsylvanians. We're the only nonprofit organization whose mission is dedicated to providing legal protection to Pennsylvania senior citizens. We provide free legal assistance to thousands of seniors each year, including victims of elder abuse and financial exploitation, elders facing housing crises and homelessness, and grandparents raising grandchildren. In our work, we assist seniors whose homes have been invaded by trespassers who refuse to leave. These trespassers often pose dangerous and threatening situations for seniors. We also assist innocent homeowners and tenants who face being improperly removed from their homes despite having a legal right to remain. We encourage the creation of a process allowing those trespassers to be removed more quickly. But at the same time, we've emphasized the need to carefully calibrate that process to ensure that it is not used to remove innocent seniors from their homes. We support Bill 180741 because it meets 2 important goals. It ensures that criminal and defiant trespassers can be promptly removed from residential properties, and it protects legitimate occupants, victims of abuse, and victims of fraud against being improperly penalized. Without the bill's improvements, innocent Philadelphians risk being removed from their homes or charged criminally when they are rightfully in a property. The bill governing criminal and defiant trespass enacted earlier this year needs the changes and clarifying definitions included in Bill 180741. There are numerous circumstances where a senior has a legal right to stay in their home, but there is a danger that the senior would be treated as a criminal trespasser. For example, seniors who lose their homes as a result of tax foreclosure may have a right of redemption under the law, but without Bill 180741, a purchaser of the property at sheriff's sale could have a senior removed from the home and potentially arrested. Additionally, in the context of a landlord-tenant relationship or instances of domestic violence, there's a danger that bad actors will make false affidavits to force seniors out of their homes quickly. Senior Law Center supports the bill's penalty for false statements. We also support the protections for seniors who are victims of lease fraud. There are times when a tenant will lease a property and begin paying rent. Months or even years later, the innocent senior learns that the person to whom they paid rent did not actually own the property. While the true owners do have a right to remove victims of lease fraud, the innocent victims should not be treated as criminal and defiant trespassers. This bill addresses that problem. Now, the problems of lease fraud is also addressed by the other bill being considered today. Bill 180978 creates a way to sue the bad actors responsible for fraudulent leases. We support this bill as one of a broader strategy to protect the innocent victims of lease fraud. It supplements the existing unfair trade practices and consumer protection law, which provides a similar right to sue the perpetrators of consumer frauds. We look forward to continued work with you to make our city a safer home for our senior population and empowering them in their fight against exploitation and abuse. We thank Councilwoman Parker, her staff, as well as the other stakeholders who've been working in collaboration. We appreciate her tireless leadership on this vital issue. Thank you.
Thank you very much, sir. Can you pronounce your name for the record, and please begin your testimony?
Hello. Yes, my name is Phil Lord. I'm the Executive Director of the Tenant Union Representative Network, or TURN. We're a tenant service and advocacy organization that's been around for a long time, 15 to 30, 40 years, depending upon the phase. We see tenants all the time. We see 2,000 to 3,000 tenants a year in our classes, and so we're acquainted with this issue from their experience. We don't protect or intend to protect people who are criminal trespassers. We don't believe that they should be protected. We think that they should be prosecuted and pursued. That's our intention. And I say that because the people who come to us aren't really the criminal trespassers. They're the victims of criminal trespassers. They're innocent people who have been tricked. And this is a business going on here. This is not your normal quote-unquote squatter. This is not the 80s when people moved into buildings to protest the lack of affordable housing. And it's not people just wandering in because they want a place to stay. These are people who are victims and move into vacant properties, properties that are not boarded up, properties that don't have security systems, property that are not licensed to be vacant and empty. These are people who moved into these properties because they got a name off of Craigslist or somewhere else, and they were told it's okay by somebody who's a liar and a scammer and a thief. And they're victims of that. And they come to our office and ask us what we can do. I'll never forget a young couple who were like in their 20s, and they had a double car seat for two little twins, less than 1 year old. And they had just moved out of one of the mother's properties, they were a couple, into a property and had used their money for a deposit. And after a couple of months, someone knocks on the door and they say they're from HUD and they have to move. And they come to our office saying, what can we do? We have no money, we just got started in our lives, and what can we do? And we tell them, the law says you're a squatter, you're gonna have to move out as soon as you can. And it's tragic, because that's the way the law is right now. The bottom line is that these people need to be protected, need to be recognized that they're not criminals, need to be recognized for the victims that they are, and fortunately, the law that we have, the amendments that we're talking about, do that. I'm really grateful for Councilwoman Parker's efforts to pull people together. It was unique, it was the way democracy ought to work. It wasn't these private consultations that we had before. We got to hear from each other, and as a result of that, I believe the police, who were dropping the ball for a long time and not doing anything with housing issues, stepped up, along with the DA's office, and decided to create a process that's workable. And we're willing to work with that, and we think that's a positive step in the right direction. But we think it's very important to do this, and we also are concerned that this law, in spite of its improvements, still is vulnerable to people illegal lockouts being committed as well as this affidavit process. This affidavit process allows owners to go up and fill out a form and gets police to come to someone's house. That's not an eviction, but it feels like an eviction if you're an immigrant or somebody who's afraid of the police or returning citizen, and we're afraid it's going to be used in that way to get people intimidated and terrorized and to move out illegally. And we hope that doesn't happen, but that certainly is a real possibility. So we're glad for these amendments. We think they're critical. We're glad for the additional bill, 180-978, about fraudulent leases. The problem is the police have not been prosecuting the real perpetrators. They disappear. No one's tracking them down. No one's finding out these people who are renting out, and so they do it again. We have to have a private right of action that will help create some kind of accountability for what they've done. So we're glad for this opportunity to speak before you, and we hope that this amendment gets passed.
Thank you very much. Can you please state your name for the record and you can begin?
George Donnelly, Public Interest Law Center. I first want to thank Councilmember Parker for her leadership on this issue and her strength in the face of a misinformation campaign that has happened, and she has been a voice of reason and a protector of the most vulnerable Philadelphians. So thank you, Councilmember Parker. In my practice, I represent tenants fighting to assert their legal rights under federal, state, and local law. And I'm here today to offer my support for Bill number 180741 and 180978. Bill number 180741, introduced by Councilmember Parker, is necessary to protect the city's most vulnerable tenants, including those with oral leases, families and properties that were recently sold, and innocent people who you've heard a lot about already today, that are defrauded by third parties that lease out properties they do not own and then run off with illegally collected rent. Crucially, this bill protects tenants and other legitimate occupants while still providing owners tools to combat criminal trespassing. It does not weaken the criminal trespassing bill passed by council earlier this year. Instead, it clarifies who is and who is not a lawful occupant of a property. It doesn't create new loopholes, it effectively closes them. The ones that were in the original bill that would have allowed unseemly landlords to illegally remove tenants from their homes. As an example of who this bill would protect, I want to share a story from my practice. Two of my clients, a couple with young children, were living in a house that was purchased by a new owner. Their lease did not end for 6 more months, yet the new owner claimed that my clients were squatters, filed an ejectment action against them. So my clients had legal counsel and were able to remain in their home for the duration of their lease, but other Philadelphians won't be so lucky. If and when the city's worst landlords use the new criminal trespassers bill to bypass the lawful eviction process and illegally remove rightful occupants from their homes. Relatedly, Bill number 180978 will protect both the vulnerable citizens that we've all mentioned at this table and property owners, both of whom are the victims when third parties fraudulently lease properties to unsuspecting tenants without consent from the homeowner. Such fraudulent leases are unfortunately quite common in the private rental market, as empty properties, high poverty rates, and a lack of affordable housing options create the perfect storm for sophisticated fraudsters to make a quick buck through illegal rentals. As George said, every tenant advocate in the city has had someone walk through their door with a lease from someone who is not the owner or manager of the property, and I've had to explain to them the legal limbo they found themselves in through no fault of their own, and we tell them that they have to leave the property. These two bills together would work in conjunction to fairly and adequately protect the interests of tenants and property owners throughout the city from criminal trespassers and fraudulent lessors. I urge the committee to vote in favor of both bills. Thank you.
I have a point of order, Mr. Chairman.
Councilman David O.
The examples just given by George Donnelly and by George Gould are not related to the ordinance. Number one, he has just given an example of a young couple who had a lease. If you have a lease, you are not a criminal. There's no criminal violation. Therefore, the ordinance as it exists does not apply to that case. And if you have a right of reclamation, redemption, if you're an heir, you're not a criminal. If there's been a sheriff's sale, you're in the property. You didn't break into the property. There is not someone living in the home. Therefore, all those situations described are not affected by our ordinance. And again, that does not allow the police to arrest or remove. It simply provides, if the homeowner provides an affidavit that they're the owner, there was a criminal break-in, they call the police record the violation, they can then apply to get in front of a judge, and the judge will hear and determine. If the judge finds that the people in the house have a legitimate right to be there, then they are not removed. They can then go through a regular process. If, however, they find that there is evidence of a criminal violation, the judge will then issue an order that the sheriff will execute. All this does, again, is get the people and whoever they're dealing with in front of a judge faster than the 6 to 14 months the people who've come before us has complained about. And these examples do not reflect on the ordinance. Thank you.
Thank you. Councilwoman Sherelle Parker.
Thank you. Point of information before my line of questioning for this panel, Mr. Chairman, and I just want to note for the record, it was noted earlier that we had a prior hearing, and at that time, Margaret Green testified against Councilman O's bill because she was concerned that people in situations like the one she was experiencing, the examples that were just given by this panel that my colleague just noted, in effect, would not be considered criminal and defiant trespassers. And so she was concerned that people in situations like the one she was going through would be deemed criminal and defiant trespassers and thus subject to arrest, fines, and a 90-day jail stay. Copy of her testimony is included in our packets. After the hearing, this is the part that's important to get on the record. After the hearing, my office inquired with the law department about Margaret Green's case, and we asked them whether or not, according to the bill that was passed as it was written, could they give us a formal legal opinion, and they replied, and I want to state this for the record, if Mr. Brown was not the owner of the property, the matter is less clear. And on the face of the bill, Ms. Green could be considered a criminal and defiant trespasser. And it's people like that example. So, you know, again, you talk about what's subjective. The law department, that is department the city of Philadelphia relies on to provide us and give us legal opinions about the legislation we put forth for introduction and consideration in this body. And they have just told us that this woman would have been considered a criminal and defiant trespasser. So I just wanted to note that for the record. It's not about what Sherelle Parker feels. That was the response of our law department. With that being said, Mr. Chairman, I want to again say a special thank you to the organizations who just testified, and I just have one question for you. The meeting that we held as a result of the resolution that we introduced regarding the task force, and we held a task force meeting across the hall in our city council chambers that was in essence a round table. It included the district attorney's office, the sheriff's office, the police department, all of your legal aid organizations, the courts. Had you ever at any time since this issue of squatting had been on the table and a legislative prescription was being proffered, was that the first time you had ever been at a round table of that magnitude to discuss the issue at hand?
For Community Legal Services, that was the first time that we were able to meet, and quite frankly, it was a very effective meeting to have all the interested parties there.
Kateria McCabe, Senior Law Center, emphatically yes, and we appreciate the collaboration to get the job done properly.
This is Phil Lord. We were at meetings where it was one-on-one, and we thought we were going to have a group meeting, and we never did until you decided to do that. So we were promised such a meeting by the previous efforts to bring people together, but it never happened.
George Donnelly, Public Interest Law Center. We were at previous small meetings that weren't as holistic and in-depth as the one that you hosted, Councilmember Parker. So that was the first time that all of the stakeholders involved were brought to the table together at the same time.
Thank you, Mr. Chairman. No further questions.
Thank you, Councilwoman. Councilman Derek Green.
Thank you, Mr. Chair. This issue has been debated for some time. I know from my experience when I represented the Office of Housing and Community Development, we had an issue in reference to people squatting into city-owned property, and we were not able to move the police to take any action because at that time, generally the police took the perspective that if they saw items in a property that looked like a person had been living there, they were not going to remove that person, and that the law department will have to actually do a civil ejectment action to remove someone from a city-owned property. So as I listen to the conversation and debate, it definitely causes a tension between those property owners who, to no fault of their own, have someone come into their property that is squatting in their property illegally, and the property owner is now in a situation where they now have to get that person out of the property. Then you also have situations where you have people who, also no fault of their own, have been duped into a situation thinking they can be in the property and find out at some point later that the person that gave them the lease had no real legal interest in doing so. So as I reflect on that, I just had some questions. In reference to the amendments that were circulated by my colleague, Councilman Parker, there were some changes that were made in reference to the penalty phase. Now, considering that some of the concerns have been raised and there's been amendments that have been put in for some of the issues that you talked about, would you have any concerns if the amendments to the bill were increased in reference to penalties, if some of the exceptions that were put into the bill were passed?
I'm sorry, you're talking about the penalty?
In the amendments that were circulated by Councilman Parker, which provided some of the definitions and changed the definition of what is a criminal and defiant trespasser. If that amendment was passed, would you be supportive of additional amendments that increase the penalty and the fines under the bill?
It would increase the fines for people who actually are criminal trespassers.
Right. If the amendments were passed as presented by Councilman Parker.
I don't think we would have a problem with that.
Because I think one of the issues that I see is that there's some concerns that we're not deterring squatters. And I understand your perspective in reference to you felt that the definition of criminal defiant trespasser was too broad. But one of the other counterbalancing issues is that are we not deterring squatters enough? And I wanted to get your perspective on that.
No, I don't think there would be a problem. If the bill is passed and makes it very clear who is a criminal squatter and who is not, I think, there should be obviously a significant penalty for people who actually are squatters.
Right, but I'm talking about the penalties from the original bill.
Yeah.
You would be okay with that?
Yeah.
And I would also concur, there's no objection to increased penalties. The concern is the innocent victims. If someone is indeed a criminal trespasser, certainly there's no objection to them being penalized, but we don't want innocent victims to be scooped up in a wide net.
Right, I understand that.
Councilmember Green, no one up here, as you know, is concerned about criminal trespassers in terms of protecting their rights. They don't have any rights. There are no squatters' rights. So we would be okay with the penalties in the original bill. What I would say is I question whether or not increased fines are going to deter illegal squatting. I question whether or not that is actually an effective deterrent. But to the extent it would be in a final bill, we wouldn't have a problem with it, because again, we're not here to protect squatters. Squatters don't have any rights.
I'm somewhat confused by your statement. So you're saying that you're not sure if any increase in fines will be deterrent, then why have criminal law then?
So an increase, so I think it's probably unlikely that a person who is a criminal trespasser is going to know exactly what the fine is per day and what the jail time is. Mm-hmm. They'll know it's illegal. They know it's illegal. That's why they do it. They know that they're taking a property. So again, I don't want to belabor this point too much. We would support the original penalties, because again, the people up here are not here supporting squatters' rights, because there are no such thing as squatters' rights.
This is Phil Lord. Let me just modify that a little bit. I think those are not our constituents, the people who are doing the illegal squatting. So the penalties you're talking about are not a great concern to us. On the other hand, as basic human beings, we wouldn't want someone in jail for 45 years for making a mistake like this. So we have to make sure we balance that out. But certainly, we're not trying to protect that constituency, and the protectors are not here. Maybe the public defender's office ought to be questioned about that. Let me just make one more comment, and that is that I don't know of a way someone moving into a building can determine whether or not the person they're talking to is an agent for the owner. There's no way that I know of that I can advise somebody that can find that out. There's no record, there's no ID, if the person's part of Century 21 or a big real estate company, that's one thing. But if a stranger comes up and says, I'm the owner's agent and can get into the property with a key, there's no way you can tell from a public record that they're not an agent of the owner. That kind of record, if it's part of a license, is very hard to find and isn't even available to the general public.
Okay. And then in reference to the other bill, Bill number 180978, would you have any concerns if there were increased penalties in that bill? And that's the bill dealing with actually fraudulent leasing of residential property.
No.
Yeah, the fraudulent lease, I suggested there be an increased fine for that. And I think it should be. I mean, unfortunately, that's a real business in Philadelphia, people breaking into homes and then leasing them out. And I think there, should be severe penalties, and I think that bill is real important, and I suggested that there be an increased fine for that.
Okay.
That's clear.
Thank you, Mr. Chair.
Thank you, Councilman. Councilman Sherelle Parker.
Thank you, Mr. Chairman. I just want to note for the record, in response to my colleague, Councilman Derek Green's questions regarding fraudulent leases and the criminality along with the fines that we just introduced in the legislation that we offer. And I just want to say for the record, that's exactly why we introduced the bill. Because right now, although we know it is illegal to do, there was nothing on the record, providing for people who knowingly enter into that business to have to be forced to pay. So I just want to note that for the, again, sometimes people, I think, develop legislation in search of a problem, and I've, tried my best not to allow that to be my modus operandi, but we developed it in an effort to provide a very tailored prescription that we thought wasn't, again, too broad. For example, again, for the MacArthur grant supporters, 45 years, the 45-year example. I want you to tell me how that, forget moral sense, but what good economic sense for the city. Thank you very much, Mr. Chairman.
Thank you. Are there any other questions from members of the panel? Thank you very much. Can the clerk please read the next panel?
Patrick Russell and Helene Lazarus.
Please state your name for the record and begin, sir.
My name is Patrick Russell. I just want to say good morning to you, unless it's not afternoon yet. Thank you for the opportunity to speak on Bill 180741 and its amendments. I'm a senior citizen homeowner in Tacony with limited resources, limited annual income. Now, because of the short notice of this hearing and having to wade through lawyer language, which can be partially or mostly incomprehensible to most of us, I hope that I'll be coherent and cohesive in my testimony. A word that my testimony has is opposition, and because it's included in my testimony, this is the particular word that I'll be using. I hope that you bear with me. I oppose this bill for the following reasons. Under 2C, the word lived is used. It is not clear as to whether or not the alleged abused victim actually had legal standing to occupy my property, if that were the case. Does the word lived mean 1 day, 2 days, 30 days? Does it mean that if I go on vacation for a month and allow someone to stay at my home while I'm away and without the permission and without my permission invites another person into the property during my absence and abuses that one who was invited, is the abused person not considered a trespasser if he or she refuses to leave? Does it mean that if the person claims to have lived in my house under the above situation and claims to have been a victim of sexual harassment or domestic violence by the person that watched my home while I was on vacation, is that person not considered a trespasser if the person refuses to leave? It seems to me that this might hamper any kind of legitimate investigation. It puts me at a disadvantage. In the meantime, I need to proceed with some kind of investigation. And in the meantime, I'm homeless. The second reason I oppose this bill is that in 2.4, anyone could say that they're renting a property from someone who claimed to be the owner or agent in good faith. What does reasonable good faith mean? The situation puts me again in jeopardy in that those who are alleging renting in good faith has access to all my personal information and possible identity theft. I'm out in the cold and the trespasser is living it up. The third reason I oppose the amendment of Bill 180741 is that what appears to be in 2E, owner or authorized agent, there's a burden that the homeowner has to shoulder some sort of investigation which isn't spelled out. In the meantime, I'm still homeless with a trespasser that has freedom of movement and able to live in my property with all of my belongings without any kind of hindrance. That person is able to come and go while this so-called investigation is occurring. My fourth objection to the amendments is 4B, which states that the owner or authorized agent has to initiate investigations. Why has the word investigation gone from singular in 2E to plural in 4B? Also, what is considered an acceptable length of time for an investigation? To say it will take as long as necessary is not acceptable. My fifth objection is that 4E, anyone can claim to have been scammed. Homeowners are still in jeopardy of becoming homeless, and their properties and IDs are also in jeopardy of being stolen. Even if people are scammed, it still presents the same problem for homeowners. Those people can or have access to the homeowner's wealth and personal information, which can also be sold on the market. My last objection is that of reducing the penalty to try and deter criminal and defiant trespassing. As counsel specified, 45 years may seem to be incredulous. However, Councilman O says that that is not necessarily the case, that particular judgment would be made. Nevertheless, it seems to me that a $1,000 or $2,000 fine is not suitable for someone who claims to be in the property legitimately and who actually is not in that property. During any kind of investigation, if that person is a trespasser, a criminal and defiant trespasser, that person can leave that property at any time without any hindrance. This puts everything that I have that's material in jeopardy of being stolen. You know, and then there's an investigation where that particular person has to be found. I have to file a complaint and so forth like that. So additional proceedings have to occur. In summary, this bill, I believe, will shift the problem from those you are trying to protect onto homeowners who could be potentially harmed by becoming homeless for whatever period of time, not to mention being burglarized again and having our identification stolen. Therefore, I ask, even though this panel has signed on to this particular bill with its amendments, I still ask that the amendments be reconsidered, that the bill might be considered for additional amendments to make clarity so that everyone involved is protected. And I just want to give you thanks for this time and opportunity to present my concerns to this panel.
Thank you for your testimony. Any other questions from members of the panel? Councilwoman Sherelle Parker.
Thank you. Thank you, Mr. Chairman. And I want to thank you, Mr. Russell, for your testimony. I don't have any questions for Mr. Russell, Mr. Chairman, but I do want to note for the record that all of the fines that are listed in this legislation, this is another layer already on top of state fines, along with potential jail time. So this is just another layer. I want to note that for the record. In addition to that, I want to note for the record that we must take into consideration that there was no standard police procedure in place. There was no procedure in place. So if someone, you know, said, I'm a victim of domestic violence, what we're forgetting is that the police department has to conduct an investigation. There was no standard operating procedure. You just can't say, I'm a victim of domestic violence. I'm a victim of stalking. We have a police department who now has a procedure in place where you take that information to them, it will be investigated. Much like if someone accuses someone of a crime and you can say, someone assaulted me, someone hurt me, that the police department will conduct an investigation, and based on the findings of their investigation, they will determine whether or not that they think the person is credible. So that's the part that we are forgetting in much of our discussion, that we did not have a system in place that would ensure that each case is investigated. And again, I want to thank the police department for acknowledging on the record that the procedure that they have in place is not the result of legislation. It's not the result of the bill that was passed. It's not the result of this bill that is in front of us. They instituted that police procedure at the directive of our police commissioner, Ross, and I'm sure they worked in consultation with our administration. Thank you.
Thank you very much for your testimony. Anyone else here to testify? All right. Come on, sir. State your name for the record, please. Beginning of testimony.
Thank you. Thank you for allowing me to testify. My name is Charles Bodie. I'm with the West Powelton Saunders Park RCO out in West Philadelphia. We recognize this is an extremely complicated issue, and perhaps it needs a little more thought. My first point, I testified, I guess, earlier this year on the previous bill, but I received no notice that there was any kind of a comprehensive meeting for everyone to come and present their viewpoints and so forth. My next question concerns the homeowner is allowed to have an investigation or supposed to have an investigation. What constitutes an investigation? How much do I have to pay as a homeowner to have an investigation? And then, if we have to wait for a judge, if I go home this afternoon and discover I can't get in my house, it's going to be a long, cold wait for a judge. How long do I have to wait to find a judge that I can't get in my house? And then we have the problem, as the previous gentleman mentioned, of our possessions. What happens if they get thrown out? How would I file my income taxes, my Pennsylvania taxes, my state taxes if I have no financial records because someone threw them out? Who pays my penalties for failure to file my taxes properly? My wife is chair of our RCO. All the records for the RCO, the computer with all the information is in our house. If we go home and can't get in tonight, what happens to our RCO, to the cases we are supposed to take to the ZBA tomorrow? So I think we need to address the property owners' rights to their possession. Perhaps we're talking about theft of use here instead of squatting or something. Maybe we need to rethink a little bit. So I thank you for your consideration, and I realize you have other things to do and you need to get on, but thank you.
Thank you very much, sir. Any questions from Councilman Sherelle Parker?
30 seconds, Mr. Chairman. Just want to note for the record and thank everyone for their testimony that no Philadelphian has to pay a fee for an investigation. We now have standard operating procedure in existence in the city of Philadelphia to address the illegal criminal and defiant trespassing, known as squatting. There is no cost. There is no fee. There is a standard point of entry to address this issue now, and that point of entry is with our Philadelphia Police Department with a new procedure that they have established that was not in existence. So when Philadelphians who were victims of criminal and defiant trespassing tell us about these stories of going to the police department and them saying they don't know what to do, they couldn't help, there was no process established. There is one now, and it is not a result of the legislation that this council passed or this legislation before us. It was an executive decision made by the police department. Thank you.
This concludes the public hearing. We will now go into a public meeting to consider the action to be taken on Bill number 180741 and Bill number 180978. The chair now recognizes Councilwoman Sherelle Parker for a motion on the amendment to Bill number 180741.
Thank you, Mr. Chairman.
Thank you, Mr. Chairman. I offer an amendment to Bill Number 180741. A copy of the amendment has been circulated to all members of the committee. I move that the amendment to Bill Number 180741 be approved.
Seconded. It has now been moved and properly seconded that the amendment to Bill Number 180741 be approved. All those in favor of the motion will signify by saying aye.
Aye.
Those opposed, the ayes have it. And the motion carries, and the amendment to Bill Number 180741 has been approved. The chair now recognizes Councilwoman Sherelle Parker for a motion on Bill Number 180978 and Bill Number 180741 as amended.
Thank you, Mr. Chairman. I move that Bill Number 180978 and Bill Number 180741 as amended be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council.
Second. It has been moved and properly seconded that the bill numbers 180978 and Bill Number 180741 as amended be reported from this committee with a favorable recommendation, and further move that the rules of council be suspended to permit first reading of this bill at the next session of council. All those in favor of the motion will signify by saying aye. Aye. Those opposed, the ayes have it, and the motion carries. This concludes the business of the Committee on Public Safety for today. Thank you very much.